other 32 was a different item, and so now we found it, and I think the defense has rectified it. I think they should just put another exhibit number on it.
Well, I think as many items and all have been in evidence. It's remarkable something like this hasn't happened.
We've been dealing with the same kind of who's on first type of thing as well, Judge, so it's completely understandable.
So exactly, what is y'all, are y'all in agreement that something was mislabeled and something's been properly labeled now and that everything is in good shape?
I think so.
Okay, both parties agree?
Is it just
with the new number? Yeah. What is 31 is apparently is an envelope that has inside of it a disc, and that disc is 32 now, and has been. The other item that was 32 is another disc, which is the Lenovo ThinkPad IEF report. That is now numbered 85.
Is that going to solve everything, Mr. Evans?
It solves my problem. I assume you want to say something about that in front of the jury too, so that they know what exhibit we're talking about.
I don't know if we need to do that, but we can if it would be.
What is it you want to have done?
Well, I just don't know if there's going to be any confusion for them about what we're referring to, because they've heard no tendering officially of an 85, but it matters not to me. I'll just refer to it to what it is.
Well, is it in evidence?
It is. It just has a different number, and they don't get to take those back with them to the jury room anyway, so I'm not sure why, but we've got to put that on record if need be.
Brian, are you satisfied with the record? Is everything together properly?
Mr. Evans, if you want to explain it, you can, and if you don't have to.
I'll let it be.
But that's your call, and you can do it if you want.
Yes, ma'am.
Are we ready to go forward?
I am.
Bring the jury in.
It's all passed to the jury. Please let yourself.
Ladies and gentlemen, I hope you enjoyed your lunch. We're ready to resume the trial of the case. Mr. Evans, you can proceed when you're ready.
Yes, ma'am. Thank you.
You're welcome.
During the lunch break, we're sort of through some sticker issues and also some other issues involving a date that I incorrectly asked you about. So I want to make sure we correct that because that's important. First thing is, did you review what we've referred to as the, of course, what we've referred to as the hot car video recovered from defendant's Lenovo?
I did.
Okay. And that was accessed on June 13th, 2014, is that correct?
That's correct.
Okay. I mistakenly asked you about some vacation searches and used that same date, but that's a different date. Is that accurate?
That's correct.
Well, while we're on the topic of the hot car video, let's talk about that for a second, and then we'll get to this item. For the hot car video search, for the hot car video.
Judge, I'm going to object to Mr. Evans referring to this video as the hot car video. That's not the title. That's not what's in evidence. So I would object to his characterization.
What do you say, Mr. Evans?
I can refer to it by item number if need be. How about this? Did you see
it's
it?
accurate?
Did you observe the video with the vet in a hot car?
I did. Per the extraction report, that
video was accessed twice. Are you aware of that?
Yes.
Let's talk about the term access, if you could, and describe to the jury what access means.
In digital forensics, there are really 3 dates that we pay attention to. One is called created. Now, created is simply when the item first came to the computer or to the device. So I want to download, some picture. When it first gets to the hard drive, it gets stamped with that created date. A modified date isn't entirely labeled correctly. And that's in part because Microsoft didn't really review it as a forensic term, but just as a user term. But what modified simply means is that there was human interaction with it. I reached for the mouse and I touched something, or I used the keyboard and I navigated to something. And then you have the last access date. Really what that date means is that the file is still on the computer. It's not human interaction. It's either antivirus may have touched it, or it's human interaction. It's a 50-50 split. Since we don't know the difference, we come to agree that it is an item that's actually on the computer hard drive. So again, your modified date is really what's the most important part. That shows human interaction. Sure, created date might reflect that, but that could be something reflecting from an auto download or something that came to the system. It's that modified date that you want to look for, because that's human interaction.
And did you see evidence of human interaction regarding that particular video?
I did.
Okay. And were you able to determine the pathway of how the defendant was able to view that video through his Lenovo?
I did.
Can you explain to the jury what the pathway is?
Okay, it all started with a website called Reddit. Reddit is social media. It lets you post comments, it lets you put articles up, it lets you put files up or whatever. And it's not just one particular item, it's a multitude of items. Again, you could have pictures, you can have documents, you could have videos, you can have everything all on the same page inside Reddit. And then you see an item that you might be interested in and you would click it. Now, 2 things can happen. One is what we call a redirect. Takes you from the Reddit website and might take you to another website like Microsoft.com or some other website. Or it stays within the Reddit website. Either way, when you click the link, something's going to happen to it. In this particular case, when the link is clicked, you can see it goes over to YouTube. YouTube is a video sharing software application web service that when you click the link, the video that you click the link of will start playing the video.
In this case, you saw that human interaction that proved that that video was clicked on because it was redirection?
Yes. Now, again, remember that on that web page, you have a variety of different things, but this one particular video you can see clearly was clicked, redirected to YouTube, and played.
Now, it goes without saying the extraction from a device is not the exclusive way to determine whether somebody viewed that video or not. Would you agree with that?
I would agree with that.
For instance, the defendant could have admitted as much during a custodial interview.
Absolutely.
And if he did so, then that extraction would corroborate what he told the detective that he viewed the video.
Correct.
Having now cleared up that date issue, I want to talk about what happened after that in the search that you just talked about before our lunch break while we're trying to get our technology sorted out. Again, I apologize. Let's talk about that. Do we have the extraction of the Lenovo now up and displayed for the jury?
Yes.
And if you'll step down with me, I think it'll be easier if you come down here. So with this full extraction up before the jury, I asked you some questions about a search for a vacation involving 2 adults and no children. You saw that, correct?
I did.
What's the correct date? Not the date that I gave you, but the correct date for that search.
That would be the 17th of June, 2014.
June 17th, 2014. Where can that search be displayed?
Now, it actually starts right here. I'm going to make this a little bigger so that we can see. Now, remember, we talked a little bit about web data. Some of the elements you got to take out. For example, we have, here's the name of the website, Sandals, and then just below it, it has Sandals the and sign, that's not an actual person typing that, it's part of that query, that's part of that lookup that we're doing. And then you have NO, number of adults equals, and a number 2. So we know that while at Sandals, a search was done for number of adults 2. The ampersand again is the next step over. Number of children equals 0. So what we have in this link that happened on the 17th at about 7:47 p.m. is a search at Sandals as you're starting to book for 2 adults, no children.
And what is the, can you actually see, looking at this code, anywhere through any of these searches, the dates that were entered as well?
I can, and let me scroll up there a little bit. When you book a reservation on a website such as this, you're prompted with 2 fields that you have to fill in. And what they do as a matter of convenience is they will put the date that you're actually at that location, at that site. It will autofill that information with the date that you're actually doing your searching with or your booking. So if we look right here, you'll see where it says calendar start date is 7/22/2014. If we look at arrival date, it says June 17th. Again, that's an autofill date that's picking it up from over here. It does that as a convenience to the user. It autofills that, you make the adjustments, that's what we see in the start date, and it's waiting for the next, the arrival date to get filled in.
And what was the arrival date that was filled in for this inquiry?
The start date here is 7/22/2014, and it shows August 22, 2014 as a second start date, but the arrival dates are showing this June. Again, that's the auto-populated. The calendar start date is going to be July 22nd in this sense, and then you see an August 22nd in this sense. So what we're doing is we're auto-filling this query twice, with two different dates that all come off of that no adults, 2 adults and no children.
All right, sir. Let me have a seat. A few other topics I want to cover with you. First thing is, I had asked you, just as an example, about some demonstrative aids that you prepared. And looking at 921, you had pointed out a particular company here having to do with psychology or psychiatry and things like that involving the criminal justice system. Remember that?
I recall that, yes.
Okay. Are you aware that the defendant was doing some web work for that company?
I was not.
Okay. Looking at this and understanding that he was doing some web work for that company, were you simply using this as an example of how the codes can be read together?
Absolutely.
Let's talk a little bit about some investigation you did into some divorce queries. Did you find anything like that?
I did.
I did. Showing you 929, flip through these documents and see if you recognize what those are and were those provided to us by email after you located them.
It does.
Okay. And these are fair and accurate documents that were recovered from the extraction report, is that correct?
That's correct.
All right, tender states 929.
Simply subject to the previous objections that we made about some of these electronic devices, Judge. Or all the electronic devices.
All right, admitted.
All right, we start with this first page. when it says full path here, we're talking about the Lenovo ThinkPad, is that correct?
That's correct.
And why don't you explain, it's very hard to see, so I'm gonna let you hold 929, and looking at that first page, explain exactly what that is from the Lenovo.
As you saw in the preferences that I talked about, that path that's at the top, they generally start from the forensic server of which we use to analyze the data with. As in this case, there is a folder called that starts out as Harris. That's my machine. After that, there is a series of numbers followed by a -1. So it's 250984-1, followed by Lenovo ThinkPad. When Cobb County makes a forensic image, and again, remember, that is an exact copy of the original. That's what you work from. They give it a name per device of whatever they want to call it. And then it follows with C, which is the main part of the hard drive, the C colon, that's where Windows operates from. And it says users. After that, it has J as in Juliet, X as in X-ray, H as in Henry, 3528. Now that's important. That's a computer user's profile that's on that particular computer. So it shows that the person using that username is actually logged in with the proper credentials in order to get in it and is about to use the internet. It follows with app data, local, Microsoft, Windows, and then temporary internet history or internet files. That again supports this is web history information. As it goes on, it talks about it has a folder called content.ie5. Now, that gets a little confusing, but IE is Internet Explorer. That's Microsoft. That's what comes with the computer. The 5 was back when they had version 5. They called it with a 5 there, and they've never changed it since. So even though today we're operating under 11, it still has that 5 that you'll see in there. After that, it has a series of alphanumeric letters. That is a folder that's inside the temporary internet history. After that, the name of the web page is this: Divorce Legal Separation Checklist with a number 1.htm. So that's a web page that deals with, once I opened it, a checklist involving divorces.
What's the date of that inquiry that you found on the Lenovo Mr. Harris had in his possession when it was seized?
May 9th, 2014 at 11:39 a.m.
May 9th.
Correct.
Talk about the documents in order. The second page, what's that we're looking at?
The
929.
The second page is the actual content of what you would see when you launch that web page, when you actually open that web page.
And looking at this, what's generally the subject matter associated with that once you launch that web page to confirm what it was?
Divorce legal separation checklist, and then it has steps of which you should follow.
What's the first step that's listed, for example?
If you have decided to change your legal name, your emergency contact information, and or change your address and phone number, you should update them through employee self-service on MyApron or another website that belonged to his employer.
Home Depot.
Correct. And so what this shows is that there was a search. And some of the data in this, this exhibit shows that there was a search, and that this search was done on Home Depot's corporate website, most likely internal, their intranet.
There are additional steps here as well, 2, 3, 4, and 5. We don't need to read all of them, but 3, for example, deals with what you should do with your W-4 form. Is that correct?
Correct.
All right. And then this will be before the jury, so we'll skip on to the next several pages, which all look similar to each other, at least the first 3 of those pages. Can you look at those and explain the significance of that?
Yeah, page 1 here at the very top, which is important. You will see where it says, "Welcome, Justin Harris." Now, what that's saying is that a user sat in front of this computer, logged into the Home Depot website as Justin Harris. And it says a date next to it of May 9th, 2014. So we know that he was logged into that website at that particular moment. And then just below that, it has a search criteria. If you've ever been to Google, you know right in the middle of Google has a search bar that lets you look up things. You're looking up movie times, or you're looking up a particular movie, or how traffic is, you would type that information in Google and Google would go get it. This works the same way. In this case, the search criteria he put in was name change, and the results came back as a result of that, which was this checklist for the divorce.
And all of those documents referring to the search are from May 9th of 2014, correct?
Correct.
The vet video that we talked about with the vet in the car, that was June 13th of 2014, correct?
Correct.
And I think I may have said the note, let's make sure we get it perfectly right. 5/9 of 2014 for 9/29, is that correct?
Correct.
Okay. The vet video is 6/13 of 2014, correct?
Correct.
The search that we just looked at for 2 adults, no children, June 17th of 2014.
Correct.
Final piece of evidence I want to ask you about is a whisper post. And you were asked very early on to look at a whisper post that was found embedded in the iPhone 5 extraction. You recall that?
I do.
When we first look at this, and I'll give you by way of example 399, when we first started looking at this in 2014, was the full exchange of the contact between defendant and this poster revealed or uncoded with that version of Celebrite.
No.
Can you explain to the jury, well, that was kind of a mouthful, is that uncommon, and can you explain why it is we weren't able to see the full chat at first?
Sometimes it's just the limitation of the software. Again, that's why you have updates. That's why when they tell you that your Windows needs to have patches done to it, you need to do it because new things are going to get discovered to you. It's no different in my world. In the forensic field, it's very common that update to software potentially is going to reveal new information even with old data, as in this case.
You're aware that subsequent to finding this initial post, because of a software update, we were able to reveal or decode the full conversation between defendant and the person who posted this. I hate being married with kids, correct?
Correct.
And now I'm going to show you states 400. Looking at 400, did you go back and look at the extracted data from the defendant's iPhone 5 to review that chat as well?
I did.
Okay. And looking at states 400, the times are correct here. It's adequately reflected that we've got the UTC -4.
That's correct.
And why is it that we were later with an updated version of Celebrite able to decode the full conversation between defendant on the morning of June 18th, 2014?
The software just missed it in its earlier version. It, again, very, very common. It's why my field search is now on version 5. Software has to get smarter because even old data gives you new results.
And is there anything remarkable or uncommon in your professional experience with Cobb County having obtained upgraded software to be able to run new extraction for it?
No, I highly recommend it. It doesn't matter if I'm doing defense work or if I'm doing prosecution work, if I'm doing civil work. Always, when you get your updates and you've got cases that are coming to trial, you run it back through it.
Thank you.
Just in that same vein, you're aware that there was a new version of Celebrite, I think it's 4.2.6, that was used in this case.
Correct.
And you're aware, though, that the forensic analysis report, you said it very simply as running it through the new software version. And running what through exactly?
It's a good question.
Thank you.
When we do an extraction of a cell phone, we talked a little bit earlier about it being the dump file. That's the whole entire contents of the device. So you take that dump file and you run it back through the new updated executable, the new Celebrite software. Again, it doesn't change that dump file. It's just going to revisit the information and show you potentially new information.
And the jury heard about this with the three previous digital forensics experts that were called from the high-tech crimes unit. But just so that we can orient ourselves, there's 3 levels of extractions that Cellebrite can perform on a phone, correct?
Correct.
And the highest level is
The physical.
the physical. And you know that that highest level of an extraction wasn't done on the iPhone 5S.
Correct.
As Cellebrite's software progresses and advances, is it now possible to do a physical extraction of an Apple iPhone 5S?
My experience has been, since I don't have this particular device at my lab, it was at Cobb's lab. I've had iPhone 5s before that did offer, but when trying to run it through, it failed. So, as he just pointed out, the 3 different processes that it allows you, the physical being the best, your file system is the next best. So when you get things that fail, and they develop a history of failing on the physical, you roll back to the next one that you know is good. So the iPhones I've had come in that are iPhone 5s, I may start with a physical, but if it fails, I'm going to roll back. And I'm going to do only that, which one of those 3 that actually work.
When the Cellebrite version 4.2.6 came out, do you know if high-tech crimes with Cobb County Police tried to do a physical, the highest level of extraction, and it failed? Or do you know if they just didn't bother to try?
I don't know either way.
Either way, we don't have a bit-by-bit copy image of that telephone.
What I have is what we call the best bit by bit. In my case, because I have the file system, that was the best. So in my opinion, I would say that I have the best, closest to the bit by bit copy of that.
Well, how do you know if you have the best if Cobb Police may not have even tried to get the best?
Only thing I can tell you is that I was provided a copy of the file that included when they did the file listing of the data. So I don't know what Cobb did because, again, my direction came from the DA's office. I knew that when I reran it through new updated software, I got new information.
Okay. And can you think of any reason at all, as a digital forensics expert, why you wouldn't try to get a physical extraction, the highest level, the best level, now that Cellebrite has rolled out a new version of the software?
I could only think of one, and I don't know that it'd be so much technical. Maybe they thought they needed a search warrant to redo it. I don't know.
Okay, well, fair enough. You weren't involved with applying for search warrants.
No, sir.
The lead detectives in the case were, right?
Yes, sir.
Detective Stoddard,
Yes, sir.
Detective Sean Murphy.
I don't know Sean Murphy.
Did you not deal with him?
If I did, it was very brief.
And now let's talk about who directed you to do things in the case. You said that you don't know why or what Cobb County Police did. You took your direction from the district attorney's office.
Correct.
Did you ever meet with the lead detective, Phil Stoddard?
I did maybe 2-3 times.
And when were those meetings?
The first one was early on. I want to say probably mid-July 2014.
Right.
It could have been a couple of months after that, less than 6. I met with him a second time. And there may have been a third time within, say, the last 18 months.
The last 18 months starting today.
Yes, sir.
And you testified on direct that when you first met, that you started working early in July of 2014. It's true, you were contacted by Jesse Evans on July the 3rd, 2014.
That sounds about right, yes.
Were you aware that there was a probable cause hearing in this case on that very day?
No, sir.
So you don't know if you were contacted before the probable cause hearing or after?
No, sir.
And we've got your report, so we have the benefit of knowing exactly what the district attorney's office tasked you to do. And before we go through it, you'd agree that your focus, the most important part of your task and your responsibility was on two elements, as you called them, correct?
Yes, sir.
The whisper, that's the red image. This one here,
Yes, sir.
states $3.99.
Yes, sir.
We know that Ross did not create this meme, correct?
Correct.
And you were tasked with finding out if Ross created this meme, correct?
I think it was twofold.
Okay.
If he actually created it and any other data that may be around that.
And that was a question at that point, correct?
I believe so, yes.
For Cobb PD and the district attorney's office.
For the district attorney's office, I know.
Okay. You don't know if Cobb PD knew whether Ross created that image or not.
Correct.
And then the second element was the vet video.
Yes, sir.
You've been involved in this case for over 2 years, correct?
Yes, sir.
You got engaged July the 3rd, 2014. We know that that was just 2 weeks from the date of Cooper's death, correct?
Yes, sir.
Were you tasked at all to determine if there was any evidence on any of these electronic devices of hatred or ill will towards Cooper Harris?
No, sir.
You weren't asked to do that.
Not specifically those words, no, sir.
Okay. What words were used then?
To find any information that may relate to that particular video, to the whisper chat,
Okay.
regardless to content.
Okay. And objectively, those two elements that you were tasked with focusing your work on, objectively, have nothing to do with hatred or ill will towards anyone.
That one's argumentative. I think the piece of evidence speaks for itself regarding mistakes and things like that. So I think it's argumentative to ask you that way from a cost perspective as well.
Please stand.
Originally, though, you were tasked with doing much more than just focusing your work and efforts over 2 years on a vet video and a whisper image, correct?
Now, originally, those were the two topics.
You testified on direct that you met with detectives, the district attorney's office, to go over all devices and identify what issues they may have, correct?
Correct.
We know that the vet video, evidence related to the vet video, is found on one device, correct?
Correct.
We know that the whisper image that the state believed Ross created was found on one device.
Correct.
Yet, from the very beginning, you were asked to go through all devices and in your work with the state, identify what issues they may have.
I don't think, there's some missing elements in your question, if I may. There's a difference between going over and analyzing. I wasn't tasked to analyze everything. I was tasked to look, one, procedurally, make sure that what Cobb was doing, I felt was correct by industry standards. Because I've had, when I work inside of defense, I've had law enforcement agents not do it correctly. Second to that, the tasks were very specific. Where the data was more or less my investigative skills coming out, where we're looking for whisper data, and I'm handed forensic images of 2 or 3 different devices. I'm going to do a general scan just to see where that data may be. And so that's what an investigation does, is it unravels in different directions.
When you met with the Cobb District Attorney's Office and detectives assigned to the case, did they go over very specific questions for you?
The only question that I can remember was if I had any exposure to whisper. Outside of that, I don't recall anything else.
Do you remember being told that they were 80% sure that Ross created that red image?
Judge, objection, and that will call for hearsay as well. One, it's not accurate, and two, it will call for hearsay of what somebody else told him.
Say your question, Tim.
At this meeting where you were asked one question, or at least you can remember one question, do you recall being told that they were 80% sure that Ross created that red image?
Right, so that
I'll
would be.
sustain the objection.
Were you 80% sure that Ross created that image?
I wasn't sure about anything at that point. I was brought in relatively new. I was handed a few copies of data on disks and started to get ready to go to work.
You wouldn't jump to conclusions, would you?
I don't know that I understand that question entirely. Can you rephrase, please?
Yeah. In relation to the red image, you just said, I wouldn't assume anything about that red image, right?
Well, the only thing that I can make an assumption, if I'm going to make one, is who the user might have been holding the phone. Outside of that, there was nothing else to tell until you ran it back through the Cellebrite update, because then you got the rest of the communication, and you could see the green little character in the chat was clearly going to be who's using the cell phone.
But just looking at the image, the meaning, right? You wouldn't just look at that and assume that Ross Harris created this image.
Objection, asked and answered and argumentative, and calls for speculation.
Judge, I have him across, and he's an expert. He was tendered and offered as an expert. Specifically, this is one of the elements that he's been working on over the last 2 years, and I'm following up from his testimony, which was, I'm not going to assume anything about this image other than who maybe the user is of the phone, which is
I'll
great.
allow it over objection. You can explore it a bit.
You wouldn't just assume at the very beginning of the case that a user created that image, right?
I would not assume that that's correct.
Because your role as a private investigator, okay, forensic consultant, is to actually do some forensics, right?
Yes, but again, what Cellebrite provided was the picture. We talked a little bit about the created file when that comes to a computer and how that has a play of human interaction and that modified is human interaction. With just that picture, nothing else around it, you can't say 100% sure that that was user created, but you can't rule out that the human that had access to the phone created it either, because you have a created file. So it could have been, but it could not have been as well. It's like 50-50.
You think it's 50-50?
It's either human that owns the phone or somebody from the web and he downloaded it. It can only be one of two.
Would it be helpful to just actually look at the image, you called it 50-50, but if you read the content, I hate being married with kids, plural, correct?
Yes, sir.
Knowing that Ross only had one child when that image was created, would that lower, or would that affect your 50-50 chance of it being Ross Harris?
Well, one thing you said was knowingly, that he had no, if I knew that he had one child,
Right.
I can't even answer that because I don't know if she could have been pregnant at the time and that would have been kids to him. I don't know those things.
You weren't provided with, I guess, more information about the context or about who Ross is to make a blanket assumption that affects your 50-50 chance of who the creator is.
Correct.
Okay. Well, that's fair. Nobody told you, though, that Leanna Harris at the time, was pregnant.
No, sir.
And in fact, all you knew was that Ross and Leanna had one child.
I only knew that from what little clip I got out of the news. Outside of that, nobody told me anything about number of kids.
But luckily, you didn't stop there. You actually investigated this image. And we now know that Ross did not create that red image. And that's because of the limitations of Cellbrite, as you discussed. Correct?
Yes.
Because now a new software version has come out, more information can be gleaned from the phone, correct?
Yes, sir.
So simply because there may not be evidence of something on the phone, or let me put it this way. Just because when that first analysis was done, Cellbrite couldn't connect the chats with that image, doesn't mean that Ross did anything to hide it or delete it in any way, correct?
Correct.
Just because Cellbrite can't detect something that's on that phone doesn't mean that Ross hid or deleted anything, correct?
Correct.
Are you familiar with applications like My Hidden Folder Pro or AVG Cleaner?
AVG Cleaner I am, yes.
Can you tell the jury a little bit about that application?
It serves two purposes. One, to try to speed up your computer by getting rid of data that you don't want, unused, unwanted, old, whatever you want to term it as, but to get rid of that old information that helps speed up your system. Second to that is it will prompt you with some messages that say, hey, certain things are out of date and probably ought to update it.
Given your understanding of this application, someone that has it downloaded on their phone, it doesn't necessarily mean that they're trying to tamper with evidence or hide evidence from anyone, right?
Not the use of that application, no, sir.
Well, we've heard questions posed to other experts in the case in digital forensics. You're not aware that there was any sort of application like AVG Cleaner on Ross Harris's phone?
I am not aware of any, no, sir.
And in fact, Cellbrite can tell you exactly what applications were found on the phone, correct?
Cellbrite doesn't necessarily tell you what they are,
Okay.
it just lists them.
It lists.
And sometimes not even by, you call it AVG Cleaner, we may see that on the actual phone, but Cellbrite may actually call the name of the file that may mean nothing to us.
Did you find a file that may mean nothing to us, but turns out to be AVG Cleaner?
I did not.
Cellbrite can also tell us if an application was originally on the phone and it was deleted, correct?
To a degree, yes, sir. can't say any because I didn't really investigate that portion of it. I can just say that in the Whisper application, I don't see that it was deleted.
Whisper was not deleted, correct?
Correct.
And so all this evidence here of filthy sexual communications with different women, okay, were not deleted. The application was not deleted.
Correct.
Are you familiar with applications that look like a calculator, but when you click on it, it's actually a place where you can save dirty photos or dirty chats?
I am familiar with some of those, yes.
Okay. That wasn't on Ross's phone, was it?
No, sir.
Do you know where the Whisper and Kick apps were located on his phone?
My understanding, it was buried inside of a folder that had the look of a different app would. It wasn't on an iPhone, they call them tiles. Your little apps are tiles. So it wasn't a tile. It was in a folder that was buried in with others.
It wasn't hard to find that Whisper app, was it?
In Cellebrite, it gives us a file listing. So no, it wasn't hard to find it just by looking at the file listings. Why? Because I use a search term called Whisper. Found it right off, didn't take any time. If I was to look at the phone, just at its face value, it would probably take me a while to scroll over to it.
Right? 10 minutes, maybe?
I don't know, I hadn't used his phone. The more stuff you put on it, the slower it gets.
Well, just to open all the folders on the apps. I mean, some of these jurors may have iPhones, and they may be familiar. You would just need to scroll through the different folders to see where all the applications were stored and organized, right?
Yes, I mean, you gave me a time limit of 10 minutes. Maybe it takes me 15 minutes. I don't know.
Less than an hour, for sure.
I would agree with that.
Okay. And certainly over the span of 2 years, someone could easily flip through that phone and find out exactly where those applications were buried, as you said.
I would think so, yes, sir.
Certainly not difficult for law enforcement or a digital forensics expert to locate this application. Maybe a little more challenging for a wife. Wouldn't you say?
I don't know the wife's skill sets. I've had some wives be real familiar with iPhones and iPhone data. So I couldn't say in this particular case, but again, I wouldn't think it'd take too long.
That's fair. You've worked divorce cases before, right?
I have.
Where one spouse is hiding stuff from the other, correct?
Correct.
Now, on direct, I noticed you spent less than 5 minutes talking about this vet video, which is one of 2 main components that you were tasked to do over the span of 2 years in this case. So let me spend a little more time with you on it. You attached exhibits to your report to kind of show exactly the time when this YouTube video was visited, correct?
Yes, sir.
You listed the website that referred the user from Reddit to YouTube.
Yes, sir.
You talked about the modified date, last access date, and created date. Not 86.
Yes.
For sure.
Check. 86.
Thank you. been pre-marked for identification purposes as Appendix 86. You recognize that as one of the attachments to your report that you created in this case, correct?
Yes, sir.
I'm going to move D86.
I don't have any objection.
And if you look, and so the jury understands, this report, this screenshot, is this of your computer?
I'm not sure I'm following that question.
Where did this come from?
Well, it came directly out of his data, but what I do is I create a web page, and then I size it, and I do a screen capture of that web page, and that's what that represents.
So you actually created the format that contains the content found on the Lenovo.
Yes.
You created the table, right?
The table gets created actually by the software as a default. I just take that and do a screenshot of that while it's in a web page form to do the screen capture with.
And what software is that?
It's web-based, so it's just,
I know, but what software did you use that you said creates the tables and the columns and all that?
you mean, which forensic software?
Yes, sir.
That would come from the, if I may refer to my report.
Sure, and let me get that for you. Would it be fair to say it's not the same IEF report that Cobb County Police High-Tech Crimes used? It's a different software, right?
It's actually the same software. It's just that what they give, when they do a full extraction, it has countless rows. Countless rows that go all the way down here. Some of it is, it'll talk about hash values. It'll talk about, path from the forensic server. It'll talk about how big the file is and some other attributes. This here was reduced by the number of columns.
I'm showing the opposing counsel with the pre-marked for identification purposes is D87.
So to answer your question, it's first generated by Encase. Encase creates a HTML web page. I then parse it by using a different application that is made by a company called Nersoft. Nersoft allows you to control those different rows and columns that gives you a much cleaner look. Doesn't change the information, but it allows you to reduce that down. Otherwise, we would need a billboard in order to print this whole thing. Since this is the part that felt relevant, I created the web page looking like this and then took a screen capture of that.
And I'm showing you what's been pre-marked as D87. That's the IEF report for, it contains the same information that comes from the Lenovo. And as you said, it's not in as clean of a format as the Nersoft software that you use, but that's what High-Tech Crimes with Cobb County Police uses, correct?
Yes, sir.
All right, I'll move D87. Okay.
Admitted.
And you would agree that here we're looking at the Chrome web history, which is exactly what you were looking at with your attachment, your exhibit. And you'd agree that on June the 13th, take a look at that last row there. The time is in UTC 0, right? So you need to subtract 4 on the time.
It doesn't say that it is, but yes, at the very top column, it has a UT, so I'm assuming it's UTC. So yes, you would have to do some subtraction there.
Okay, and if you subtract 4, that would put it at 4:59:09 PM, correct?
Yeah, 87 is just tough to read because of the number of columns in it. But that's what it looks like, yes.
And this comes from the state's evidence. You'd agree that it has a column where it says how many times that video was visited, correct?
Yes, sir.
Okay. And how many times does it say there?
2.
Okay. That doesn't mean that he viewed it 2 times, correct?
Well, it says he went there twice. He clicked on the link twice.
Take a look at your report. Isn't it true? He did not click on that link twice. In fact, that's exactly what you found in your report.
If you could refer me to what paragraph we're talking about.
What's your conclusion there? Just read that to yourself. Let me know when you're ready.
It doesn't have anything about the number of times. It just says the user clicked it, in my opinion, that the user clicked the video link in Reddit and was, in fact, redirected to YouTube where the video would automatically play as a result of the mechanisms built in YouTube's website.
Correct. And then D86 shows that it was clicked 4:59:09, and then at 4:59:10, 10 seconds. That's the second visit, correct?
Correct.
Right? So he only clicked on the video link once in Reddit, and then it automatically redirected him to YouTube where it refreshed, correct?
I'm not agreeing with that. In fact, I disagree. One, we don't know if refresh was even activated at YouTube. Second to that, nothing in either one of these documents that you've presented indicates that he clicked twice inside Reddit, once inside Reddit. What we know is because it's visited twice, he saw it twice. We don't know where. We know it was redirected. We know it landed on YouTube. And we know there factually because there's 2 what we call URLs that show that they was actually visited twice.
Okay, when are the 2 times that he visited that video then?
You say, why is the timer?
When?
I'm sorry.
What are the 2 times that he saw the video, that he visited the video?
Both on June 13th, 2014.
Right?
One at 4:59 and 9 seconds, and the second one at the same date at 4:59 and 10 seconds.
How
So
long is that video?
several minutes.
Almost 6 minutes?
I would agree with that.
You agree it's impossible to watch a 6-minute video within 1 second?
Sir, this isn't indicating how long he watched it. As far as I know, he had 2 tabs open. Since he's a multi-user of multi-browsers, he could have had 2 tabs open and watched the video on 2 different tabs within his browser. That's not uncommon. I've seen that a lot.
But you don't, I mean, there's no evidence of that. You don't know if Ross did that.
I don't know that he didn't do it either.
Sure. Over 2 years of work, you never included in your report, it's possible that Ross Harris watched this 5.5-minute video 2 times. You never said that.
And that is correct.
The state didn't ask you to offer that opinion, correct?
No, I believe the document stands for itself. It actually says, not only using Cobb County high-tech crimes method, but my method both indicate visit count that is generated, that column name is generated by the software. The forensic software titles it that, not us forensic specialists. It called it visit count, and it plugged in a number 2. And if you look just above that, there's another video that's called How to Guarantee You Win at Home in SEC. It has 1, a number 1. we talked about a little bit that Reddit is not just this one video. It is a bunch of stuff. By percentage, majority of the stuff on that Reddit page that showed in the forensics, by majority, only one count. There are a few where you had 3, and a couple you had 4. You have a 6 in this one down here that deals with Home Depot. So 6 different times he went to the Home Depot website.
Because he's a web developer for Home Depot, right?
Yes, sir.
Okay.
But it shows strong interest. You have 6 different visits to that. Majority of them have 1 visit. This video that involves this doctor and the dog in a hot car, twice.
Are you saying it shows a strong interest in the vet video?
If I take my calculator out based on a percentage of calculation of how many different entries on that Reddit, and more than 80% of them are 1, it's more likely he had more interest in that one link than those others that he only had 1.
Did you do that in this case?
I looked at all of them.
Did you punch in a calculator and determine the percentage of links clicked on?
I took in my own mind that I had multitude of entries in Reddit.
Okay.
And I scrolled through, visually approximating how many of them had a 1,
Okay.
how many of them had more than 2.
And how many?
Majority of them have 1,
Give me a number.
80%.
You would agree that there was never a parsed search for how hot does it get in a parked car? Correct?
I searched for that,
And you didn't find it.
but I wrestled with it. And here's why. You see, in the forensic world, we're very specific people. If you hand me a dictionary and tell me to find a word in it, I'm going to ask you what word. I'm not going to just look for every word. So I tried things like hot car, and I didn't get anything. But then I said, what words do I need to use? Hot car with a youngster, hot car with a toddler, hot car, hyperventilating child, all those different variations. How many do I try? And I said to myself, in the years I've been investigating data, I'm going to start it at a different approach. I'm going to look at his web history and see what common terms he might use to search data with. But the history was gone. Majority of it was deleted. So I couldn't start with anything. After putting in just hot car, I knew I couldn't put any other words in. I couldn't put in kids. I couldn't put in children. I couldn't put in child. I couldn't put in, just so many different words come to mind. There's just no way to do that without having something to start from. That's why the results turned up with just hot car. No, I got nothing.
You testified on direct, though, that Chrome was the only Explorer where the web history had appeared to be deleted.
That's correct.
There was Firefox.
Yes, sir, and I searched that diligently because the data was available. So what did I find in there? Searching out high schools in Cobb County. I don't know why, but there was a bunch of that.
Maybe because he's a high school football referee. Did you know that?
I did not, but
What else did you find?
I found where he was looking up guitars.
Maybe because he plays in the church band.
And I play a guitar, so I identified some of the websites that he'd been to.
What else did you find?
Where he was checking for patent information and Home Depot information and job offers and some other elements. So Firefox was all intact. I could search it. But Chrome was not.
Right.
And that's that Dr. Jekyll, Mr. Hyde. It was well hidden on the Chrome, but in the Firefox, it was all available.
He wasn't hiding the vet video. He told the police that he watched it. You know that.
But that wasn't a question. Even if you have them on cross, It does have to be a
I'll
question.
rephrase. You were aware, and it was asked on direct. Ross Harris told the police that he watched that vet video, correct?
Yes.
He didn't hide that vet video.
The vet, he didn't hide it. However, remember, the Chrome history was deleted June the 6th. Everything before that is off limits. It's gone. June the 6th. But June the 13th, that dog video came out. Maybe he's crafty enough that said, I got to tell him about that because I didn't hit the delete button to get rid of my history. He knew that video was there.
Maybe he was crafty enough?
I've done a lot of cases. I've had some outwit me. I have chased people all over the globe for lots of government agencies. Intentional move. So yes, I think he was crafty.
You think he was intentionally clearing his cache?
Yes.
There are a number of reasons why one would clear their cache, correct?
Yes.
It doesn't necessarily mean it's nefarious, correct?
Correct.
You know he's a web developer, right?
As I am, yes, sir. I'm aware.
Phrasing of the question, backing off.
His testimony has changed. I got him across.
That's my class.
My understanding of that particular website was on face value. I saw the website. I did some research because I was unfamiliar with that website.
Who told you to do that research?
Nobody. I did it on my own when it came back in the preferences.
You did that on your own. When we came back from lunch, your testimony was that you only used that Griffin Psychology website as an example of what you found in his preferences, correct?
Again, my morning testimony was I went and I investigated. I looked at the website. just in the off chance that you or Mr. Evans would have asked me a question about it. So this afternoon, I later learned that he had done some sort of work involvement with that with that company.
Okay. Who brought that to your attention?
Mr. Evans did.
And Mr. Evans has been your point person in this case, correct?
Yes, sir.
He's the one that assigns you tasks in this case, correct?
For the most part, yes, sir.
Okay. And this morning, you swore to tell the whole truth about finding this website and the preferences and suggesting to this jury that he was learning about juries and forensic evaluations, correct?
Yeah.
I don't think anyone made that suggestion.
That's exactly what he testified to.
No, it's not. What he testified to is using the example of what was on the left side of the page versus the right side of the page. There wasn't any testimony about what evidentiary significance might be attached to that, but an example.
He has them on cross, he has wide latitude. Jury will have to determine from the evidence.
When you read that website out, you told the jury, listen, I looked at this website. I did some investigation. I want you to know that when you go to this website, okay, you can learn about juries and forensic evaluations, and you thought that was suspicious, right?
As at about 9:45 this morning, yes, sir, because that's when I looked at it.
You've been assigned two main issues to look into over 2 years. Yet, on your own, you're willing to testify to the jury about something that you just threw together in the last couple of days?
I wouldn't say it was thrown together. One, it was 30 months from the date of engagement to today. And second to that, the list kind of grew over time. The report you're referring to was done March 2016.
I'm going to move this to top of the response to the certifications already.
I think I want to go through the witness. I want to look at all the exhibits, please.
It's already in.
It's already in, and why we have to put stickers on it.
The business records already in. Anything that came from Google, attached to that business record certification is in evidence. There's a disc from one exhibit.
All right, so I'd like the board to do the witness. All right, so I've been presented with some documents from Google. Did you get any documents from the company Google that you were asked to review as part of your responsibilities in the case?
No.
Okay. Have you looked at any Google chats or Google information that was provided by Google as part of your responsibilities as the forensic investigator that was asked to assist with the state?
I did not.
You have no familiarity or know nothing about these chats that apparently come from State's Exhibit 601 from Google?
I do not.
How about screen names or anything like that? Do you know anything about that?
I do not.
Judge, I'm going to object to those exhibits, I think for obvious reasons.
But there's nothing before the court.
Well, I'm going to move to 88, 89, and 90, Judge. They were in response to a Google, or a search warrant to Google, and the response and the disk is already in evidence, along with the certificate of authenticity. That's Exhibit 601. This very content was inquired about after the break on direct examination.
What is your foundation?
Well, the foundation's already been laid because the certificate of authenticity is in.
What is your argument, Mr. Evans?
He's got no personal knowledge to authenticate these separate exhibits, whether they're pulled off of that disc or not. He's already testified he has absolutely no familiarity with it. So while those might be original business records that are sitting over there with the state's exhibit sticker, these records he's holding in his hands with the defense exhibit stickers, there's no authentication for it if this witness knows nothing about them.
Judge, the foundation has already been laid with the certificate of authenticity. I've got him on cross, and I should be able to ask him very specific information about items that are already in evidence. They're just singled out.
I sustain the objection.
You weren't made aware that Ross Harris was a web developer that worked for Griffin Psychology, Michael Griffin, PhD, were you?
No, sir.
Okay. Were you aware that Ross Harris and his friends at Home Depot had created a new web development company?
No, sir.
Were you aware that Griffin Psychology was a new client of Ninth Hour Development?
No, sir.
Right? Did you know that Ross Harris had been serving as the web developer for Michael P. Griffin, PhD, all the way back to February of 2013?
I did not know that, no, sir.
Over the break, were you shown any of that?
No, sir.
Did you tell Mr. Evans that you were going to testify that GriffinPsychology.com was something that Ross Harris deleted from his preferences because it has something to do with juries and psychological evaluations?
No, sir.
You just decided to do that on your own?
I used it as a reference in the preferences page. And thinking that you might ask me questions about that website, I looked at it at about 9:45 this morning.
But you didn't bother to ask about the context of any of that information?
No, sir. The best I recall, Mr. Evans was in court while I was on standby. There was no way to ask him about it.
You made a point to discuss this website, privateinternetaccess.com, correct?
Yes, sir.
Do you have that up there? States 922.
Yes, sir.
Right. And you found that this website was visited on Ross Harris's computer. Right?
Yes, sir.
Now that you know that he's a web developer, he had a new business, private clients, you agree that this sort of service doesn't mean that he's planning some sort of crime?
I would think if he's a web developer, he'd create his own. He wouldn't use another third party. That's what I do.
Have you gone to this website?
Yes.
Okay. So you're aware that it is sponsored by Forbes, MSN?
I'm not aware of that. I'm just aware that it's a VPN, a virtual private network.
And a lot of companies might use it, correct?
Yes.
Right? And in fact, Ross Harris, he didn't purchase it, right?
I'm unaware if he did or not.
So you're willing to testify that this piece of evidence was found on his computer, yet you didn't do the follow-up to see if he even purchased the service?
No, sir. Again, that was discovered about 3 days ago.
Yet you were willing to testify about it?
I'm willing to testify. I know he went to that website. Yes, sir.
You didn't know that he didn't purchase it?
No, sir.
There's a photograph of a dad and two children on a bicycle, correct?
Yes, sir.
This isn't necessarily marketed towards people that are planning to tamper evidence?
I think that would call for speculation.
This day.
What else did you do over the last few days that you didn't include in your report?
Well, again, that report was done in March of 2016.
You didn't update it.
No, sir.
The last few days, you could have done that, right?
I could have done that, yes, sir.
Were you directed not to?
No, sir.
When you found this a few days ago, when did you turn it over to the state?
About 48 hours ago.
Okay. Did you plan for it not to be disclosed until this morning?
No, sir. I sent it to him about 2 days ago, so
You didn't have any control over that.
I did not. In fact, some of it, I believe, came as late yesterday,
What was that?
the preferences.
The preferences. You mean the Griffin psychology? That slide?
More particularly, the slide about the browser history being deleted, those 4 screens, not just the Griffin. There's not even a printout for Griffin.
You testified that in looking at the Firefox search history, you found that there was searches for patent, correct?
A few of them, yes, sir.
And because it's more than one, you would agree that that appears to be something that he is assigning a little more attention to, that topic.
I think you're confusing the topics. The Reddit that I talked about earlier and the percentage of 80, because there's ones, we're talking about his whole Firefox internet history. I don't know what those compare to. It's pretty voluminous, the Firefox history. It would take boxes to print out all of those.
And he didn't delete any of that.
None that I could tell. Again, I saw a lot of it. I was able to search it. And with what I searched it with, didn't find what I was looking for, so I went back focusing on Chrome.
What were you looking for?
Again, I wrestled with the topics of hot car, child in a hot car, taken by heat, list goes on.
Okay. Murder?
I'm sorry?
What about murder? Did you look for that?
No, I did not.
Okay. What about homicide? Did you look for that?
I did not.
What about malicious intent? Did you look for that?
I did.
What'd you find?
I did not find that, but I did find references to OCGA, Official Code of Georgia.
Okay. And what statute was that?
It didn't have a statute. It actually just listed that Official Code of Georgia. Sometimes web links don't always put the whole link on the data, so you only get fragments of it.
So what did you make of a Georgia citizen that was looking at Georgia law? What was the conclusion that you drew?
I guess some interest or some question about law.
Could it have been informing an LLC?
I would have went to the Secretary of State's office for that.
And he did that, didn't he?
I can't say that I didn't see that.
You didn't see it?
Again, I didn't know of his private business.
Fair to say that when you look at all of someone's electronic devices, you can learn quite a bit about their private business.
Yes, sir.
Okay. So you learned about his private business, correct?
To a degree, yes.
You had boxes and boxes and boxes of Firefox web history that you could have gone through that he did not delete, correct?
Yes.
You could learn quite a bit about someone based on what they do on the internet.
Someone or the spam that they receive or the pop-ups they receive, the junk that they may get through their browser, all the other miscellaneous garbage that can come from the internet.
What else did you search for?
I believe that's it. I mean, it was very limited.
Okay, so hot car, child, murder, homicide, or no, you didn't search for murder, you didn't search for homicide, but you did search for malicious intent.
This is the thumbnail here. Yeah, that's the bad dot. That's what that means. This here, next to the screenshot there. With the wrong PC. Oh, it is. That's what it's category.
And what's been pre-marked for identification purposes is D91. You talked a little bit on direct about searching for age of consent. Is that the image that was found on his phone?
I believe so, yes.
I'm going to move D91.
Okay.
Admitted.
This is a screenshot of the age of consent in Georgia is 16, and there is no close in age exception, correct? That's the first couple of lines.
You're saying this page 1 is a screenshot.
Yes.
It doesn't look like the screenshot that I was able to see.
I'm sorry, and maybe I'm using the wrong technical term. What is this?
Well, it looks like it's been a retyped of what that message would have been.
Who retyped it?
I don't know. I need to look at it closer on. And I need the actual picture blown up, but it doesn't look like the complete content of the thumbnail picture.
Mr. Rodriguez, is that iPhone 5? It is. Just speak these on, and you can readers up.
If you want to go through that with me, you can. Do you have any reason to believe why this is not from the iPhone 5S?
I don't.
Okay. All right, and you would agree with me that this first page of D91 says the age of consent in Georgia is 16, and there is no close in age exception, correct?
Yes.
And then, though the offenses are a misdemeanor rather than a felony, in cases where the perpetrator is less than 19 years of age and is no more than 4 years older than the victim, correct?
Yes.
The crime of statutory rape makes it illegal for a perpetrator of any age to have sexual intercourse with someone under the age of 16 that they are not married to, correct?
Yes, sir.
And then it says, this law specifies that a defendant cannot be convicted on the testimony of the victim alone, correct?
Yes, sir.
Some other evidence must be present. This offense carries a minimum sentence of 1 year in prison and a maximum of 20 years, correct?
Yes, sir.
If the offender is 21 years of age or older, the minimum is raised to 10 years in prison, and the offender is subject to sex offender.
Okay.
Okay? And I've read all of the content that's on this first page of D91, correct?
Yes, sir.
All right. You would agree that this appears that Mr. Ross Harris researched a statute in Georgia, correct?
On the iPhone, yes, sir.
Okay. So certainly that would be evidence that if he wants to research a statute in Georgia, he can, right?
Sure, yes.
He knows how to.
I can't testify if he does or doesn't. I can assume he does.
Okay. And you would agree, he never Googled search for cruelty to a child.
I didn't search for those terms.
Did you find any evidence that he searched for cruelty to a child?
No, sir.
Did you find any evidence that he Googled or searched for homicide?
Judge, I have to object to the phrasing of the question. There's already been testimony, there's only search history for this 17th and the 18th. This makes it sound like there's no evidence of search at any time, so I think it needs to be qualified for what was available to be looked at.
I'm talking about all the electronic devices.
Go ahead.
In all the electronic devices, you didn't find any evidence that he searched for homicide.
No, sir.
You didn't find any evidence in any of his electronic devices that he searched for murder.
No, sir.
You didn't find any evidence that he searched for malicious intent.
No, sir.
Okay.
But just like in similar cases, where I may be investigating a drug dealer, I might search for money and I might search for drugs, but just because you have money doesn't mean you sell drugs. So sometimes you search for things, unless you know his words, his vocabulary, you can't say that something doesn't exist. Maybe he misspelled it.
Well, fortunately, we know a little bit about his vocabulary based on his interview with police, correct?
I never watched that interview, sir, so I wouldn't know his vocabulary. I was faced with looking at data. Data doesn't talk to me.
Did you know that he used the phrase malicious intent
I had learned that through the news.
through the news?
Yes, sir.
Did you discuss that fact or allegation with the district attorney's office?
No, it did not.
They didn't ask you
No, sir.
to search for malicious intent. Or no, you did, right? You did.
I did search for that.
Okay. Did they ask you to do that?
No, sir.
You did that on your own.
I did that on my own.
Did you tell them, hey, there's nothing?
I did not.
You didn't tell them that you didn't search for malicious intent?
No, sir.
Is this the first time that you're actually letting the district attorney's office know you never searched for malicious intent?
I spelled it correctly. I can't say that he spelled it correctly if he searched for it.
Is there any evidence that he misspelled malicious intent in a search?
Sir, I can't answer that question because I don't know how he could have misspelled it. He could have misspelled it a variety of ways, and that got him what he was looking for. I don't know. I just know the way I spelled it, it did not come back.
The Home Depot benefits summary that you looked at, Mr. Evans talked to you about on direct just after lunch regarding divorce. Mr. Harris never searched the word divorce, did he?
No, sir, I found the word, I put in the word divorce, and the document that had divorce in it came back. I traced it back and found the document where he searched up name change.
You have no idea why he would be searching for a name change. I mean, you've talked about a lot of things you don't know. You don't know why he searched for name change.
No, sir.
But what you do know is that he did not search for divorce, correct?
Based on what I seen, I got several returns on the word divorce, but the one that stood out, that to me was the most recent, was the one that associated with name change.
Again, he did not search, type in the word divorce. You did, correct?
I did in the forensic data.
And the word divorce just happened to appear on a document, correct?
A document that he clicked on, yes, sir.
And you'd agree that the documents that are available on this My Abrams account have to do with benefits, correct? Maybe something that comes from human resources at Home Depot.
I assume so.
Well, because you were curious at evidence of a divorce, did you bother to look to see if he had Googled a divorce lawyer?
No, sir.
You didn't bother to do that?
No, sir.
Okay. Did you come across any evidence that he had searched for a divorce attorney?
No, sir.
Did you come across any evidence that he had researched alimony,
No, sir.
custody of a child,
No, sir.
and the boxes and boxes of web history that you had available across multiple devices? You never found anything related to a divorce other than this search for divorce that you did.
search within his data, yes, sir.
It's just a document that's got the word divorce in it.
I'm sorry, I didn't hear you.
It's just a document that has the word divorce in it.
He puts in the word name change. And he gets back a return, a link that talks about a checklist for divorce. He clicked that link. There must be some interest in that.
Doesn't mean that he wants to have a divorce.
Again, there's some interest in that.
You don't know that.
Sir, I don't know that there's not.
Because you need to do more follow-up investigations, right?
I could do more follow-up, or I can say that you put in names change. You didn't click a document that deals with name changing only. You didn't back out of it because you put in something wrong. You clicked a link that is associated directly with a divorce checklist.
Okay. Maybe, just give you the benefit of the doubt, maybe he had some bit of interest in divorce. He had no interest, and you found no evidence of having an interest in murder, correct?
Using just that word, correct.
Any evidence that you went through, no evidence that he had any interest in murdering someone.
Again, I didn't search the data for those terms.
No interest in finding out what malicious intent was.
Correct.
Let me have a moment, Judge. Talking about what he may be interested in, possibly. Is it possible that he was interested in purchasing a home?
I don't have anything support or not support that.
You didn't see any evidence on his electronic devices of all the searches for a home?
I don't recall seeing that, no, sir.
Did you see a Zillow account?
I don't recall seeing one, no, sir.
A Remax account?
No, sir.
What about emails? Do you have access to all the emails that came from Google?
If they were on his device, I would have had access. Did I search them? No.
Did you have access to the emails that were on his device?
If they were on his device, I would have, yes. I didn't search for those, so I don't know that they were on there or not. Google doesn't store always, unless you tell it to, emails on your device.
Well, you went through the Whisper application on his phone, showing you what's been pre-marked for identification purposes as D92. You agree that is a Whisper and the associated chat from the iPhone 5S, correct?
I'm sorry, could you ask that question again, please?
D92 is the mean and associated chat, the Cellebrite connected between those two items, the mean and the chat.
I would agree, it appears to be that. It's got an incorrect timestamp on it. But outside of that, I would say it looks like it came from that, yes.
It says -5, correct?
And it should be -4.
It should be -4. Other than that, does this fairly and accurately depict the mean and the chat associated with this photograph?
It is, and that, again, it's the first time I've seen that document.
I'll move D92.
Or what, no,
You'd agree that the meme is house hunting, so excited, right?
Yes, sir.
And since we talked about his activity and interests on June the 13th, you would agree that this chat was on June the 13th?
I would agree with that much, yes.
Okay. The user that created the meme is named, or the name of the user is Yada Ambient, correct?
Yes, sir.
And that's not Ross Harris.
Correct.
All right. Ross Harris is in green, correct?
Yes, sir.
He says, I just started as well, correct?
Yes.
And the other user says, it's amazing. Do you have a family? And Ross says, I do, correct?
Yes.
And then the other person says, my husband and I have one daughter, smiley face. I'm expecting. How many do you have? And Ross says, just one right now.
Yes, sir.
Do you know if Ross and Leanna had any interest in having more children?
Based on that, I would say yes.
Ross asks, where are y'all looking?
Yes, sir.
She says, in Atlanta, Georgia. Ross says, where in ATL? She says, Lithonia, correct?
Yes, sir.
Ross says, we're looking around Kesaw, and you take that to mean Kennesaw, correct?
I would agree with that.
/ Marietta. correct?
Yes.
He says, wow, that's cool. We're waiting to see if we'll get qualified by our bank. And that's the end of the conversation, correct?
It is. Now, if I may,
Sure.
if I was searching his data to see if he was looking for a house, and we take this picture by example, house hunting, 3 exclamation points, so exciting. Most of us would probably put the exclamation points on the end of the sentence, not in the middle of it, as it appears in this document. You see, when we're searching data, we have to be specific. We have to know enough that those exclamation points are going to be in the middle of the sentence, not at the end, or we get nothing back.
And Ross didn't create that image.
No, sir, but you indicated he was searching for houses. If I wanted to agree with that or not, I would have had to known those exclamation points are out of place.
But if you're just looking at his activity on June the 13th, like we know that you can do, you would have seen that this communication was going on June the 13th, 2014, just 5 days before Cooper passed.
The communication in this document was not the focus of my part of the investigation.
Because the focus of your investigation was whatever they told you to do.
Not whatever they told me to do. They gave me, it's like running a 100-yard race. They got me to the 20-yard line. They gave me ideas of things that they wanted investigated further. I carried it the rest of the way.
And they didn't ask you to look into whether there was any interest or any evidence on his electronic devices of a future plan to purchase a family home.
No, sir.
Is it your understanding that they did want you to look at that?
We never talked about it. So to say they did or didn't, I can't answer.
Well, you would agree that as far as clearing your cache, that's not necessarily something that a web developer, that's something that a web developer may want to do, correct?
I would agree with that. So why didn't he clear both of them? It's the same computer, the same performance, but one browser gets cleared and the other does not, and they're on the same computer.
Well, is your cross to tape?
I'm close to it. Judge, if I can just, well, if we can take our break and I can set up my last point and use the Mondo.
I think that's fine, that's what I was interested in, I know the witness is gonna have more time. Ladies and gentlemen, close your notepads, open minds, close lips, have a break.
Let's all rise up here, please. Please watch yourself going down. Please watch yourself going down.
Before the parties get off for their break, have y'all conferred with each other about scheduling? Seems like things may have changed.
Well, I think we anticipate we would close and move it in. I really doubt that.
Oh, I do too. I was thinking about moving.
I think we'll probably risk my lunch.
Okay, good. And that's on schedule, and if you're a little over that, that's okay too. I just think they should know.
Yes, ma'am. I mean, she also, the two will be fine.
I think so. Yeah, Murphy's got it. You think?
I think he was the one.
Yes, I think so.
I'll get back to you.
Right over past lunch, it sounds like we'll be okay.
Thank you.
Everybody get a break.
I underlined mine. Oh, you did? Just check. Then I didn't turn that down. I thought that was only for mine.
Oh, you did. Oh, you're good. Your volume is at you. Yeah. Well, on that.
I was plugged into this.
Oh, it was.
You should listen to me. I might have figured it out.
You put have a laser on that little thing, but you should have sounded it right back.
I forgot to turn it back on.
Oh, boy.
Jeff, this should be a lot better now. Testing 1, 2, 3, 4.
How you doing, sir? Good, doing good. Doing good.
jury would be.
No. Judge,
Yes,
I
Have moved it.
Yeah, everybody say that.
sit right here.
And it tilts.
All right, we're back in session, the defendant's in the courtroom. Mr. Evans, do you have something you want to talk?
Sure. What's being displayed right now is a portion of part of the evidence that I objected to, and you sustain our objections. It's now on the monitor pad for the jury to view, so we would object to that. There wasn't any foundation there wasn't any proper foundation laid, and it's not relevant to the cross-examination of this witness since he has no personal knowledge about anything being here.
What do you have to say?
Your Honor, it's not the same piece of evidence. This is actually the state's evidence 601. So I'm simply going to be confronting the state's expert with a piece of evidence, the state's evidence that's already in.
I'll hand that over to Mr. Evans, so I can look and see if that's.
Right.
He
It's
has
in
a
Mr.
different
Lincoln's
impression.
computer.
Okay. I'll assume, I have no reason to disbelieve that that's not that piece of evidence. Now let's get to the second part though. How is it relevant? Even cross-examination has to be on relevant topics, and this witness having established on voir dire that he has no personal knowledge about anything from Google, has nothing to do, was not asked of looking at it, have a relevant objection to this being disclosed. And he's already been crossed about that.
It's about the very website that in his demonstration this morning, he testified that he actually visited this website. So
Which
I'm gonna-
website? I mean,
I'm sorry,
understand.
griffinpsychology.com. And so I'm going to revisit the piece of evidence, states 921, griffinpsychology.com, that was on their piece of evidence that they admitted on direct.
But it's on the Google website, right?
Yes, ma'am.
I don't see why I can't argue and close an argument about the significance of these types of things and use one piece of evidence against another piece of evidence, but it doesn't mean it's a relevant topic to cross-examination if a witness has no personal knowledge about that.
I'm going to look at my notes. You need to make a copy of what you're doing.
During the direct examination of this witness, and for the record, I was given a copy of States 921 this morning for the very first time. I'd never seen it before. There was an original report that was created by this witness in March 29 of 2016. By his own testimony, he came up with these pieces of evidence, turned it over to the state 48 hours ago. For the very first time, we're seeing it today. And so in my attempt to explore this piece of evidence that the state introduced, there was a side-by-side list of the contents of Chrome preferences, that's States 921. And I would specifically cross-examine him about why he selected this one website to make this example and demonstration to the jury, griffinpsychology.com. And he talked about how he even followed up, and I went to the website. Yet, all these other websites here, basecamp.com, DevTools, lesscss.org, Home Depot Dev, Many of these websites that are listed on the right-hand side of the preferences that were allegedly cleared or deleted manually, those are web development websites. And so with this line of questioning, I would have the ability to impeach his credibility, bring it into question through a thorough and sifting cross-examination of a topic that they brought out on direct, and show the jury that he could have used any one of these web development websites to prove that, hey, the Chrome preferences have changed manually. But there's a very, very specific reason why he chose this one, because he wanted to put on this show about Dr. Jekyll and Mr. Hyde, and that, well, the suggestion is he went to griffinpsychology.com because he wanted to learn about jury trials. He wanted to plan, okay, for his involvement with the criminal justice system. Somehow the suggestion that he's researching how to deal with a criminal case. The fact of the matter, though, is that even in the state's own evidence, and I would submit that this piece of evidence that's already in evidence, I should be allowed, with a thorough and sifting cross-examination, to confront the state's expert with a piece of the state's evidence that's already in evidence. And it's not just some random piece of evidence, it's electronic evidence. And what is it? The griffinpsychology.com. And what it shows is that in May of 2014, there is a Google chat going on, and Your Honor may recall we've done a demonstration of this Google chat with two of the witnesses that have already testified, Mr. Alex Hall and Winston Millen. Those individuals, including Mr. Harris, were involved in creating a new business, Ninth Hour Development. And so they're talking about here adding griffinpsychology.com as a new client to their portfolio.
All right, I think we finally got to what the proffer may be. Now, what's this step?
I don't want to tell counsel how to do his job, but I don't have a problem with him asking, well, are there other websites that you could have looked at? That's a fair question. Are there other things that you could have looked at within the two screenshots that were put together and presented? But there's a different story altogether to talk about some chats between individuals that this witness has no familiarity with at all. What basically was expounded to the court just a moment ago was, I don't know, maybe a good argument for a jury during closing argument, but it's not the proper way to ask this witness about relevant information that's before him. I don't have any problem with him asking about anything that's on the pages in front of this witness in terms of other places that he could have looked to make the point that he was trying to make, which is demonstrative age. And I will respond to the first part that counsel said too. They've had this since 2014 whenever we turned over discovery. This is not something given them 48 hours ago. It's on the very Lenovo disk that they now mark as Defendants 85. The raw material to get what you need to for these demonstrative aids has always been available to them. This is not something that was merely provided to them 48 hours ago. What was provided was the demonstrative aids that came from that raw material.
All right. Well, as to the proffer, and as to what I hear the intended purport of this examination relates to the business that was formed. We've had testimony on that from two of the people relevant to developing that business and what they were doing. They would be the proper people to testify about this. It would be hearsay from this witness, and I sustain the objection.
Your Honor, may I add one additional thing to my proffer?
Well, honestly, that could go on for forever.
It
Go
won't.
ahead.
It won't, though.
Well, I know, but I know about walking in quicksand too.
I don't, but
Well, you are.
I just
But I
want,
will let you.
thank you. I'll just point out that this one line here, I'll be removing unused CSS and JS tonight. That is directly related to the kind of activity that a web developer might engage in, which is the sort of suggestion that this witness has tried to explain means that he's trying to delete or hide evidence.
And who is the I'll be, I didn't
Ross
write that.
Harris.
Okay, that's from Mr. Harris?
Yes, ma'am. So it's not hearsay, these are his statements here.
That's not, this is not the proper witness to cross-examine on that. So I sustain the objection. So you might pull it.
Brian, can you pull it down, please? Sure.
Are you ready to resume, or do you need a minute?
No, I'm ready.
Give me a minute.
Let's all rise on the jury, please.
You have the disc? Okay.
Please be seated.
Mr. Royer, just resume the cross-examination, please.
Thank you, Your Honor.
You're welcome.
You've been in the case for 30 months, is what you said, correct?
Yes, sir.
And how much are your fees?
I'm sorry.
How much are your fees in this case?
Me personally or PM Investigations?
You personally?
I might have made $4,500.
How much time did you spend in the case? Do you bill by the hour? How about that?
I do.
Okay. And how many billable hours?
As a company, we probably build roughly 4 to 5 hours a month.
Okay. And who's in your company?
I'm sorry?
You asked how much you make personally or the company. Now I'm going to follow up. Who else is in your company?
My wife, and I've got a part-timer.
So how much did your part-timer make off of this case?
He didn't make anything.
Okay, so all the money that was generated in this case came to you and your wife?
No, sir, it went to the corporation. I get paid by the company.
You pay yourself?
Yes, sir, I am the chief executive officer.
You are PM Investigations?
Not as a single person, we are incorporated, S corporated.
So how many billable hours did you and your wife put in to the work in this case?
We averaged about between 4 and 5 a month.
And over the span of almost 30 months, your report was focused on 2 things, the red image and the vet video, correct?
Originally, yes, sir.
Well, it is late as March 29th, 2016, correct?
As that report reflects, yes, sir.
There's no new report that you've created, right?
No, sir.
So everything that you've testified to, okay, all that was done after March 29th, 2016?
No, sir.
Okay, wasn't. You just decided not to put it in your report?
Again, it was late documents that came to surface.
You just waited until today, months after making this report, to let any of us know about it, right?
I didn't let you know anything. I let Mr. Evans know.
Thank you.
Redirect.
So all of the stuff that you brought to court, that came from the Lenovo extraction, is that correct?
Yes, sir.
Okay, so defendants 85, the Lenovo extraction that we looked at just a while ago, all of that information was available to them from their own exhibit, is that correct?
Correct.
You just went and added the arrows to show what the significance of it was about 48 hours ago?
Correct.
But the actual data itself, the information, the highest value, that was always available from the original extraction?
Correct.
You were asked about your work on this case and the number of hours. Is this the exclusive case that you've been working on since you were retained to assist us as a consultant?
Heavens, no.
And just give us a ballpark estimate, how many other cases you've been working on in addition to the state versus Justin Ross Harris?
In the last 30 months?
Sure.
Probably 25 or 30.
Okay. You know that among other things, the defendant is charged with criminal attempt to commit sexual exploitation of children and dissemination of harmful material to minors. Are you aware of that?
Yes.
Okay. Have you worked similar cases where you found that a person has deleted some information but not all of it?
Yes.
Can you explain?
I would object as to relevance, other cases.
Yes, sir.
Okay. Let me ask you about this particular case. Do you find it significant based on your training and experience that some information was deleted but not all of the pertinent information?
I do.
Okay, and explain.
Most of the time, when you're investigating, especially data, where there potentially could be law enforcement interacting with seizing and collecting the evidence, most of the time the defendant doesn't know that law enforcement's going to come and get that equipment. So they tend to delete things, or not delete things, keep things. So in this case, when you're looking for data where a person doesn't know that law enforcement's going to collect the equipment, and you see the internet history is completely gone, that's, in my opinion, somebody being prepared for not somebody like me seeing everything. So they go through the process of deleting, but leaving the other stuff behind to potentially have you go down that trail, go down that path, look at that information, focus on that. In my last 15 years, and I have trained countless forensic investigators, sometimes they just look at the data on the surface. They don't dig. They don't go to that unallocated space. Why? It takes effort. It takes a lot of work. It takes time. Data doesn't just jump out. But if I look on your desktop and I can see something, generally I stop my investigation. So you have to learn to dig further. So in this case, when you evaluate the history of one and the history of another, and even on the iPhone where it's limited of what you have on those 2 dates, raises the bar of suspicion.
And when a person is assessed with something, such as sexual type content, is it uncommon based on your investigative experience that they would not delete all of that?
Yeah, it's very common that they won't go through and delete it. Why? A lot of them, we refer to them as collectors. They don't want to have to go back out and get it again. Run the risk of getting a trigger where maybe law enforcement is doing an online investigation. You know, we watch some of these TV shows, To Catch a Predator, for example, and yet they still do it. So when we're looking at the data, we know that, again, most of these people, they don't want to lose what they have. They'll actually move it to a thumb drive, or they'll move it and burn it to a CD-ROM, or, we've even had cases where they'll upload it, to a cloud service because they want to keep it, they want to hold on to it.
Or even move the application that may, so it's not readily visible when you power on the phone if it sees.
Absolutely. Again, what most forensic specialists like to start with is looking what the naked eye can see, not necessarily the forensic eye. So if you've got to start moving the tiles around, you've got to start opening up folders, you've got to start taking something that was encrypted and decrypted. You've got to do a recovery. It takes time. It takes work. It also takes a special set of skills to figure out what somebody may have had a computer. Let's say they've had that for 3 years, and I spend 5 hours a month looking at that. I'm never going to catch up to their use.
Now, this jury's already seen, and I believe I showed you during the break, the actual phone itself when I powered it on and showed where the Whisper app was inside a weather icon. Do you remember that?
I do remember that.
Okay. So I want to ask you about that. How does that view differ from, say, a mere Celebrite pull from a cell phone give us an analogy that will explain how Celebrite's not going to give you the full picture unless you go and look at the handset.
It's a great question. Take a deck of playing cards. We know that there's 52 and 2 jokers. Brand new deck, you open it up, most of the time the 2 jokers are right there on the top. You know that. You take one of the jokers and you slide it in the middle. You don't know where it is, you just slide it in the middle. You put the deck back in the box. Now only you know that you slid it in the middle like that. Here comes Celebrite, or I take that same deck of cards, I open it up and I put all the 52 plus the 2 jokers on a table, and I just scan them off the top of one another. Then I flip them over and I realize I have 54 cards. That's what I expect to see. I don't know that the order has changed. That's the difference with Celebrite. Celebrite lets you see the folder structure just as those cards are laying on a table. They don't see that the joker has been slid in the middle of the stack.
Okay. Let me ask you about what was provided to you in terms of your ability to conduct your more limited investigation in this case. Were you satisfied with what Cobb Police gave you in terms of the extractions?
No, I had to ask for more.
Okay. And when you were asked for more, did you get exactly what you asked for so that you could complete your investigation?
I did.
Okay. Just give an example. What did you ask for that you wanted that you thought would be more beneficial than the initial extraction?
Well, what Cobb High Tech did, and did well, is that they use an application that's made by a company called Magnets, Internet Evidence Finder. Well, it gives me the results of what that forensic tool found on these devices. But I wanted to dig deeper. So I asked for forensic images of the computer hard drives. Those are what we call EO files. Just in layman's terms, what that basically means is a bunch of files all compressed together will match exactly the hard drive. I needed that to explore deeper. The Internet Evidence Finder won't always give you data from the unallocated space. It'll give you some of it, but it won't give you all of it. I wanted to search those areas. So I asked for copies of the forensic images, and they provided.
I want to ask you a little bit about what we initially asked you to focus on. Is it uncommon for somebody to retain your services and have you start at building block A more limited point, but then ask you to expand your work?
It happens all the time.
Is that what happened in this case, or as defense counsel asked, were you only asked to look at 2 areas to the exclusion of all others?
No, it expanded. We had 3 blocks, A, B, and C, that we were working from. We're now in X, Y, and Z. We kept building those blocks of requests.
The point that he focused on in terms of the initial reason that you were engaged to come and assist with this, admittedly, was that for a more limited purpose at first?
It was.
Okay. By the end of it, had you been asked to look at a number of things, including some of the things you testified about here?
Yes.
Staying on that topic of being retained and working with law enforcement and the support capacity in this case, you're asking questions about meeting with Detective Stoddard. Was he the exclusive person you met with, or who did you have most contact with?
I had the most contact with you.
Okay.
There was handfuls of people at times in present.
Were there times when there were actually group meetings where maybe Stoddard was present or even not present?
Yes.
When it comes to your review of the extractions, and you're asking questions about one extraction versus another, until you look at that extraction, are you going to know what's on it?
No.
Okay. And if you found a video on one extraction, would that mean that you wouldn't look at the others as well?
No.
Okay. Explain.
Here's the thing that we've learned, especially in cases that I've dealt with that deal with child pornographers. They will take data, download it.
Object to testimony about child pornographers, that's not relevant.
Sustained.
Okay. Yeah, go on. All right, let me ask you a question about this post that the defense counsel brought in. This is an important point. The age of consent. This is specifically, looking at Defendant 71. They're talking about a post. A couple points here. First of all, this is dealing with statutory rape, I believe, correct?
Judge,
Yes.
I'm going to object to leading.
Okay. What's the topic?
That's directed, he can do that. Go ahead.
What's the topic that's addressed here? What crime?
Statutory rape.
The age of consent for statutory rape, it's different than exploitation of minors,
Judge,
correct?
I'm going to object to that question that asks for a legal opinion.
I sustain that objection.
Go on to this topic. you're asked about the iPhone 5 and the dates where search activity could be seen, correct?
Yes.
Okay. And the 2 dates that are remained in terms of the browser search activity were what dates?
Was June 17th. And we saw parts of June 6th, 13th.
No, and that's part of the question. So in terms of the browser activity, that only showed activity from the 17th and 18th. Look at this post here in Appendix 91 and tell me the date of that.
February 19th, 2014.
Okay, so this involves something that was researched back in February, even though it was not included in the browser data that was from the 17th and 18th, correct?
Correct.
In other words, you could look to other areas of the phone to see if there had been prior searches, even though it may not have been deleted from the search history.
Yes.
And does the absence of you finding a search, we'll use the iPhone 5 for example, mean that a search was not conducted?
No. In fact, we talked a little bit about unallocated space. It does fill up. So what happens to the data that fills up? In layman's terms, it falls off the edge. In technical terms, it's what we call overwriting data. If something is overwritten, I take this document and I overwrite it with another document, I can't always see what's under it. That is truly deleted beyond recovery, overwritten. And where does that exist? Unallocated space. So when you delete something and it goes out to unallocated space and it gets overwritten, none of us in this room are going to be able to do anything with it. We can't recover from that. It's gone.
And if we use this as an example, go back to Appendix 91. Had the defendant not used or taken a screenshot apparently of this statutory rape statute, we wouldn't have found that this was searched because the search history was deleted prior to the 17th and 18th, correct?
Jack is deleting.
I'll try to rephrase it. Would you have found this if that history was deleted?
I would not necessarily have found that if it wasn't already captured. Now, part of that is we have to understand the difference between the iPhone and a computer. Unallocated space is going to be much larger. City of New York, more people, more spaces. The unallocated space of an iPhone, very small town worth, very limited. Therefore, you're overwriting data faster than you are with a computer.
Thank you, sir.
That image, D91, he didn't delete it from his phone, did he?
This image he didn't delete. However, this image is a thumbnail. You see, the difference between an actual photograph and a thumbnail. Thumbnail is a very small picture. The big picture that you see results in this thumbnail getting created. It does that for 2 reasons. Number one, the next time a person wants to see it, it loads faster because he's pulling from this thumbnail. Number 2 is it creates a record so that if you wanted to search something similar, it could draw from that. So this being a thumbnail, he wouldn't have access to that from his iPhone to delete it. The actual picture itself, he would. The thumbnail is in a small little database file that holds this information. He can't just go into it and delete it. You can get some tools that you could download and go through and probably scrub that database to get rid of it. But that didn't happen in this case because it's still around.
You didn't correct Mr. Evans when he asked you and referred to that piece of evidence as a screenshot. Are you now saying that it's not a screenshot?
I'm saying that I can't tell that because I need to see closer here. However, it says at the top of this second page that it's a thumbnail. What I can't see, because the print on the second page is so small, I have blue down here at the bottom that might be a number that I can't see in the thumbnail.
It might be a screenshot, right?
You talking about the thumbnail is a screenshot?
That photograph there. It might be a screenshot that he actually took on his phone and saved as an image on his phone.
It could be, yes.
When Mr. Evans asked you about that screenshot, you didn't launch into this explanation about how it's a thumbnail and it may not be an image that he took, right? You didn't do that.
I don't know if you're talking about a forensic image or you're talking about a photograph image. If you could clarify, please.
I'm just trying to, let me just be plain spoken with you. There's a lot of photographs on his phone, correct?
Yes, sir.
Did you look at them?
Not all of them, no, sir.
Okay. There's a bunch, right?
There is a lot, yes, sir.
And no evidence that he was systematically trying to delete the filthy images that were saved on his phone, photographs that were saved on his phone, correct?
Correct.
You would agree that a web developer that uses Google Chrome exclusively as a web development tool, okay, there's a perfectly good reason for why they would clear the cache, correct?
That would call for speculation, so I would object.
He's an expert in electronic evidence. His testimony is that because Mr. Harris cleared his cache only on Google Chrome, that there must be some nefarious reason for it.
I just said it's an awful broad question.
If you knew that a web developer was clearing their cache only on Google Chrome, because Google Chrome is what they use for web development, that's not some unusual reason to be clearing the cache, correct?
If I said yes to that, I might agree a little bit. However, the video of the dog is in his Chrome, and it wasn't deleted. What that has to do with web developing, I don't know. If it were in his Firefox, I'd understand that. But it's in his Chrome. So that doesn't tell me that he's using that exclusively for web developing.
You could use Google Chrome for your web development purposes and not clear your cache every single day, right?
As well as with Firefox, yes.
There's no evidence that he was trying to hide any of his activity on Firefox, right?
I do not see that, no.
Okay. And you have no way of knowing, okay, why he chose a day in particular to clear his cache or not.
I do not know why, no, sir.
Now, you believe it's suspicious because he deleted his cache, correct?
I do.
Now that you know that he's a web developer and there's a perfectly good reason for him to clear his cache, you think it's suspicious that he didn't clear his cache in Firefox?
Absolutely. In fact, because I build websites too, I manage all of mine, and I've built them over the years. I frequently will install on a computer both Firefox, Chrome, Internet Explorer, Microsoft's latest Edge. Why? Because as I'm developing a website, I want to see how it looks in all the browsers, because they all treat that website differently. So in this case, yes, it's extremely suspicious to me that you have one browser where he clears his cache, the other one he leaves it intact.
You also thought that it was extremely suspicious that he went to a website, griffinpsychology.com, and then it was deleted from his Google preferences, didn't you?
No, sir, it's not deleted from the preferences. That's where you're mistaken. It's actually changed names. It dropped the www dot in front of it. It's on both sides.
You thought that him visiting that website was extremely suspicious, correct?
I knew nothing of the history of that website. So I seen that particular website as a site that he had accessed, that he had control over, that he was clicking on. That's how it ended up in his favorites, which is no different than private internet access. He's accessing it.
And of all the websites that you could have used as an example, you chose that one because you thought it was extremely suspicious, correct?
No, it was the only one I thought I was unfamiliar with.
Right. And you familiarized yourself with that website, correct?
Absolutely, I didn't know what it was.
You went there,
Yes, sir.
right? And you thought it was important to tell this jury some of the suspicious things that you found on that website, correct?
Yes, sir.
But you didn't take the next step and check with Mr. Evans or check with the other evidence that you were provided to see, is he actually a web developer for that website? You didn't do that.
No, sir, I thought he was a web developer for Home Depot.
Because you didn't know that he was starting a new business, correct?
Correct,
You didn't know that that new business was a web development business, correct?
correct.
You didn't know that they had plans for the future beyond June the 18th, 2014, correct?
I still don't know, sir.
You don't. But you could have found that information out if you had looked at all the other activity on his devices, right?
I could have, but didn't.
You didn't.
Because this morning, I thought, between you and Mr. Evans, would ask a question if I knew anything about that website.
And before I was given an opportunity to ask you a single question, you were corrected, and you came back after the break to specifically make clear to this jury that what you originally found is very suspicious. There's a perfectly good reason for him to have had control over that website, correct?
I can't say there's a perfectly good reason for it. I don't know why he chose to work with that company. I don't know that. I do know this. I've built sites for plumbing companies, air conditioning companies, and guess what? When my air conditioning goes out, they're the ones I call. I know that factually. So I don't know what his relationship is with them, but I use that as a marker in the preferences because we could see that something had changed in it. It dropped the www dot versus the other, private internet access, wasn't in there. That was the point.
Now that the district attorney's office has made you aware that Griffin Psychology is a client or was a client of Mr. Harris, do you still think it's suspicious that he was doing some web development work on the side? Is that suspicious?
I have to object to that. Mischaracterizes the testimony. He has said that it's suspicious that the defendant happens to do web developing. That's not what the testimony's been.
He doesn't like us.
You want me to ask again?
Please.
Now that you were made aware by the district attorney's office that Ross Harris worked as the web developer for Griffin Psychology, do you think that's suspicious?
No, but I do say this, puts him in control of his preferences. So those 2 dates of the history being deleted certainly is his ownership. The fact that privateinternetaccess.com was added as his favorites is certainly pointing to him.
Did you consider the possibility that private internet access was something that Ninth Hour Development, his new business, would want to use? Did you even consider that?
No, in fact, I considered if they're web developers, why wouldn't they make their own?
When I asked you how much you had been paid, let me clarify. How much did your company bill for this case?
Approximately $31,000 over the 30 months, about 5 hours a month.
So, admittedly, I should have followed up with another question. But you had only paid yourself and your wife $4,500. Is that your estimate?
Approximately, yes.
But now we know that your company actually billed what, $31,000?
That's correct. Let me add to that the Cellebrite license itself, just to buy the software, the hardware dongles that come with it, $6,300 on renewal. That's just that software. That's not including in-case. That's not including the rent. That's not including anything else. So yeah, that's about what we billed.
For 4 hours a month?
About that, yes, sir.
And Celebrate, the software that you're talking about as being expensive, Cobb County Police, they have that, right?
They have their copy, but it's ran by what's called a dongle. Might be a new word for you as well. Dongle is about the size of your thumb. It's like a USB drive. You have to plug it in the computer to get it to work. When you buy a copy, you get one. That means I run it at my lab. If I want to run it at your house, I got to take the dongle with me. The one at the lab isn't going to run anymore without that dongle. Cobb County Police might have one dongle. All the cases they get involved with, they've got one dongle. They can't give me the dongle, and I certainly can't sit down there and do my work, not without running in interference with the rest of their cases.
That's all I have, Judge.
No.
Next witness.
Judge, I ask that the witness not be released, just be subject for recall, please.
Can we fresh talk schedule real quick?
Can the witness step down?
Yes, ma'am. Dustin? You solemnly swear affirm the truth, the truth, the whole truth, and nothing but the truth, so help you God. I do.
Please be seated.
So if you will, I'm going to use the microphone the best you're able. Introduce yourself to the jurors and spell your first and last name.
My name is David Dustin, first name D-A-V-I-D, last name D-U-S-T-I-N.
And Mr. Dustin, where generally do you live? We don't have to have an exact street address, but where in the state?
Adairsville, Georgia, sir.
And I want to ask, where are you employed?
I'm self-employed.
And what's the company that you run?
I run a company called Dustin Forensics
And how long have you run Dustin Forensics?
since about 2002.
Okay, so that's been up and running for some time now. I want
Yes,
to
sir.
talk a little bit about what you do specifically at Dustin Forensics. Can you articulate for the jury?
Yes, sir. So we specialize in 3D laser scanning or other methods of data capture. We do a lot of training for law enforcement, a lot of training for like forensic engineering companies, things like that, that want to use the technology to be able to capture data. And so, for instance, in the example of the the forensic engineering companies. So if they have a bridge collapse or something like that, they want to be able to analyze this, use the data to be able to analyze perhaps a structural failure. As it applies to law enforcement, they use it for the mapping of crime scenes and then also for crash scenes. Those are the two most common applications of it. And so we instruct agencies and companies in the use of the technology and then also the software. I've trained approximately, I would say at least 60 individual police agencies across the nation on how to use this. We've done advanced training. We've trained agencies, military agencies, so we've done training for the U.S. Army, for NCIS. We've done some things with the Army, but I don't remember how in-depth it was.
And what sort of training, education, and background do you have that qualifies you to both do these 3D crime scene mappings and then also train other agencies on how to use them?
Right, so training, I came out of engineering, had a very in-depth background in machine controls. So things like robotics and automated machinery. So I would design equipment, I would also program the equipment to function a certain way. And then as far as education, I've graduated high school, a small city in Wisconsin. Interestingly, I served a 4-year apprenticeship to become a journeyman maintenance mechanic, pretty involved. And then I did some education related to, it was an associate's degree for something called electromechanical technology, which is basically robotics.
And then I want to ask you about the background specifically tailored to 3D crime scene mapping, and I want to talk to you about Faro. Are you familiar with the Faro mapping software and the mapping equipment?
Yes, sir. So I purchased one of the first units that Faro, which is a U.S.-held company, purchased one of the first models. It was easily one of the first 50 in the nation, and we were one of the first 4 or 5 that used it in any kind of forensic application. When we started, there was, and I don't mean to use the pun, but when you do a laser scan, it captures a lot of data points. Well, when we started, there really wasn't much out there for how to apply this technology. So we were able to, we developed our own software plugins for the other software that we used. I developed an iPad app to be able to visualize the image exports from the scan data. Very popular with law enforcement and also engineering companies, things of that nature.
And the Faro technology, once you purchased it, that began a long-term relationship between your company and Faro, the company that actually creates the 3D mapping equipment.
Yes, sir. So because of that, because of our early involvement and learning everything, there was, I shouldn't say everything, but a good share of what the equipment will do and what the software will do. Then, and we're also a beta tester, so when there's a new piece of equipment that comes out, we field test it. We also are beta testers for the software, have a very in-depth relationship with both the developers of the hardware, and then also the developers of the software. I probably communicate more with the software developers at least once a week, introduce or explaining different bugs that I may have found in the software. So it's a very very close relationship that I have with the manufacturer.
And is that the equipment, among others, that you are training law enforcement around the country how to use?
Yes, that's correct.
As one of the agencies that you trained, Cobb County Police Department, based on your work with them on this case and some other cases.
Yes, sir. I've trained Cobb County in the state of Georgia. Let's see, I've trained Pooler, I've trained Warner Robins, I've trained Cherokee County, Cobb County. I thought there was one more in there, but yes, sir.
What about some of our federal agencies? And because we're in Glenn County, I'll ask you specifically about NCIS.
Yeah, I spent quite a bit of time with NCIS. I actually worked with them on at least one case. I actually did all of the laser scanning, and this was a drive-by shooting case. And so I did all of the laser scanning, all of the post-processing, created the deliverable that they could take to their court system. I also helped them on another bullet trajectory case, some dwelling in Quantico. So, and I've trained NCIS on, I want to say, for sure twice, and then perhaps on 3 different occasions, and then also some of them have attended some of my advanced training classes.
So in addition to the training, in addition to the individualized work that you've done, have you testified as an expert in 3D mapping and forensic crime scene mapping using this 3D laser technology before?
Yes, sir. So I've testified, I've been identified as an expert here in Georgia, also in the state of Tennessee. There was one more that I had actually forgotten about, only because I think I said my name and yes, but that was in Texas, Longview, Texas. I was attending a hearing down there. We had used some laser scanning technology to scan an underground bunker for, it was a doomsday prepper, and there was a homicide.
Okay. And in fact, the Georgia case that you referred to, that was a case that was prosecuted in Cobb County. It was a murder case as well. Is that correct?
Yes, sir, that's correct.
And you were received as an expert in 3D laser scanning and crime scene mapping?
Yes, sir, that's correct.
At this point, Judge, I tender David Dustin as an expert in 3D laser scanning and crime scene mapping.
And then he can testify as an expert.
Ask you a little bit of background before we get into the technology, and you understand we're going to have to break up your technology. We're not going to be able to finish this today.
Yes,
but
sir, I
we'll
understand.
Get into it as far as we can. So I want to ask you this. Can you tell me, first of all, does your son work with you?
Yes, sir, he does.
Okay, his name's already been raised during this trial.
Yes, sir.
His name is Eric Dustin, correct?
Yes, sir, that's correct.
In addition to the 3D scanning, which is the primary purpose of your company, do you sometimes assist law enforcement agencies with other requests, such as the GoPro videos that were seen by this jury in this particular case?
Yes, sir, actually, we do a lot of support, all pro bono, for agencies across the country, anywhere from NYPD. We had done their training, and then we have assisted them from time to time. We had worked on a case out in, I believe it was Salem, Oregon. This was during a training exercise. They had a homicide. We scanned the project. Effectively, I completed the entire project and deliverable that they used for the grand jury hearing for that particular case. And my gosh, many other agencies across the country, my phone rings a lot.
Most of your company makes money by doing the training, is that correct?
For the most part, yes, sir.
But in this particular case, since I know the defense will likely ask it, you're performing your services pro bono, just as you did in the other homicide case.
Yes, sir, that's correct.
Okay. I want to talk a little bit about the scanning process in general, and would it help you in explaining the process? We actually showed them what the Faro laser scanner looks like.
Yes, sir, I think it would.
Why don't you step down? I don't want to break your equipment, so I'm going to ask you, I'll help you if you need it, but mostly I want you to move your expensive equipment so we don't suddenly leave pro bono and become paying customers. I want you to try to explain in layman's terms what 3D scanning and 3D crime scene mapping actually is. And you have, for the record, a device in front of the jury now. It's called the Faro 3D scanner?
Yes, sir, that's correct.
Okay. What is it that we're able to do when we do 3D crime scene mapping and 3D scanning?
Right, so inside of this device, it's a handy little, it's very light, you can hold it with one hand. Inside of this device, there's a laser, and amongst other things, there's a GPS sensor, there's something called an inclinometer to check its level. But there's a laser in this side of the cabinet. There's also a camera. So what happens is the laser emits a beam, and this mirror spins. Okay? So as that mirror spins, it's basically painting the area with light. So anywhere that beam touches, it will stop, and it will come back. It will return to the scanner. The scanner calculates the distance based on the constant of the speed of light. Okay? So that returns to the scanner. So while that's happening, the base of this scanner is rotating also. So what it does is the base rotates 180 degrees, and then when it's finished, because it's scanning out both sides, it has a complete 360 degree, I think it's actually 362 with overlap, sorry. So it has basically everything that it can see in a direct line of sight. It has some limitations, so it cannot see through things. It's not an X-ray machine, right? So and it's also, it struggles with certain things like glass. So as an example, if you remember from some of your high school classes, what happens to light is when light hits glass, it slows down. Okay. So light moves about 300,000 kilometers per hour, I believe. When it goes through glass, it slows down to about 200,000. So glass presents a problem for laser scanning. It's just part of the technology.
Now,
all of them.
I want to ask you some of the terms. You talked about line of sight and the importance of accounting for line of sight when we scan a scene.
Yes,
when you say line of sight, what is it you're referring to, and how do we account for issues that you might have for items that are not within the line of sight?
Right. So line of sight just means that if it is not, I don't want to use acuity terms as in like for optical for our eyes, but if the scanner can't see a point, then it can't record it. So what we do in that instance is we'll take the scanner, we'll complete a scan. Now, I forgot the second portion. Once it's finished doing the laser capture, then what happens is the mirror rotates again, and the camera, there's a camera inside of this housing, and the camera snaps images. So it captures a series of 85 photographs, and then it stitches those together into what's called a panorama. Okay? And it then takes that color, and it applies that color to the scanned dots. So for instance, then this banister, because it's a certain shade of brown, the camera has captured that, and so it assigns that color value to that particular point in space.
So the electronic scans, it meshes with the photographic evidence so that the scans actually incorporate the colors that are being scanned as well?
That's correct. So, and there's also a void below the scanner. They call it the nadir, or a void below the scanner, because it can't see through itself either. So you'll see a circular void below the scanner. So then what we do is, in order to capture more efficiently, or more effectively, I should say, the data, you'll move it to another position and you'll perform another scan.
And why do you move it to another position? Use this podium as an example. Would you expect to catch anything on this side of the podium?
Right. So if we scan from this position, there would be a void behind that podium, because the scanner can't, I don't want to say see, but it is not able to detect any information back there. So what we would do is we would move it to another position, and we would scan again, and this time filling in that additional void. Now we can also do, because it's so small, we can actually take it off of here. Say there was evidence or something under the table, you can actually place it down on the floor as well.
So you don't have to use the tripod, in other words.
You do not. You could also invert the scanner and put it down into a hole if you needed to.
And it still, you'd use the same process
Yes,
to create a scan?
That's correct.
Okay. And for some, I'll call them more involved scenes, like an outdoor scene, is it sometimes necessary to take multiple scans from multiple locations within that scene?
I would say the largest scene I've ever scanned, we did approximately 70 scans. It's a downtown area.
And then let me ask you this. What about smaller scenes? How small can you get with Faro technology? And is there another handheld device that can sometimes assist?
Yes, so you can do tighter environments with this type of scanner. It isn't the best suited for that, so we have another type of device. We have another type of a device called, it's called the Freestyle, is the product name for it, but it's typically just referred to as a hand scanner. And so the way that you operate it is you power it from this Windows tablet, and then the scanner itself, so this is not a laser scanner, this is something called the structured light scanner. So what it does is it projects an infrared pattern of dots, and it's got an infrared camera that can see those dots. And what it does is it interprets those dots and how they are conforming to an object, and because it can view them from two places, then it can triangulate those dots. Okay? So it's a very handy way. It has some of the same limitations. So because it's using light, it still has issues with items that are reflective, or items that are, where it could cause refraction or something like that.
Okay. But using a device like this for a more enclosed space, it's very similar technology, would you agree?
It's similar. It's just not a laser, it's structured light.
Okay. Using this smaller handheld technology, is that what you refer to as the handheld?
Yes, sir.
Could you scan a smaller scene as well as a larger scene using the Faro 3D scanner?
Yes, sir, and then you can merge the data together.
Great, that's my next point. You can set that down wherever's convenient for you, Mr. Dustin. I want to ask you about merging the data, and I want to ask you about a term that you use called stitching. So, yes. Let's talk about merging the data and stitching. You're familiar with those two terms, and you and I have discussed those in the past, correct?
That's correct. So there's a term called registration also. What registration is where you take individual scans, and when you first perform a scan, each individual scan has its own coordinate system. Okay? And so in order for these scans to work together, you have to combine them to a single coordinate system. So the software will perform what's called registration. Think of it as pieces of a puzzle. Okay, so if I've done 5 scans, I've got 5 pieces of a puzzle. Okay, each one shows a different area of the environment that you're trying to scan. The software will analyze that and it will determine how those scans fit best together, and then it will register them.
And then I want to talk about what's stitching?
Stitching, well, stitching can apply to a couple different things. Usually we just refer to it as merging.
Okay, explain merging.
Okay, so merging is where you would have different scans and then you could merge them together. So as an example, I could take a scan of that podium, I could isolate that, I could merge that into a different set of scans if it was advantageous or required for a certain process.
All right, and then let's talk about how the actual scans are displayed once the scanning process is accomplished.
Right, so the software itself allows you to visualize the scan. You can maneuver, if you will, through the laser scan data in 3D space. So you can move behind, over, behind, or around objects. You can also perform measurements in the scene. So it isn't unusual to pull measurements from this laser scan data.
All right, and let's talk about what you did in this particular case. Before we get to that, I want to talk about a scan that you had accomplished in this particular courtroom. Did you
Yes, sir.
ask somebody that you trained and worked with to scan this courtroom so we could demonstrate the technology?
Yes, sir, I did.
Judge, do you want me to continue on, or
How long is the next piece gonna take?
it's going to go over 4:30, probably?
How much?
Give me 15 minutes. How about that?
No, I'm being realistic. I'm not.
4:45?
4:45?
Yeah.
Well, let me be more professional. No, thank you.
I'd rather give you a higher than a lower and get in trouble, Judge. So
Well, you wouldn't get in trouble, but I appreciate it.
Yes, ma'am.
That you would approach it that way, because I think that's a very valid way to approach things.
Thank you, Judge.
And I take back the nah, and I say no. No, we're gonna close our notepads, keep an open mind, no conversations at all with anyone in any way whatsoever. As you know, the evidence will come to you from the witness stand, so don't explore anything else whatsoever. Have a very pleasant, lovely evening. We'll resume at 8:30 in the morning.
Please watch your stuff going down.
When you said 15 minutes, I was thinking 4:35, and then when you said the other one, nah.
Yes, ma'am.
Yeah. Everybody, have a good evening. See you.
Thank you, Judge.
Judge, I wanted to perfect something on the
Please
record.
do.
I can do it now or in the morning, it's up to you. Okay.
What would it be, sir?
I just wanted to, I guess, either renew or perfect my motion for mistrial this morning. In particular, I want to call something to the court's attention. The court indicated that the jury had a right to view a piece of evidence. Piece of evidence that we're talking about, that I made a motion for mistrial on, is State's Exhibit 650. That is, says defendants, Hyundai, Tucson. But that's not what the jury saw. What the jury saw was a manipulated piece of evidence. It wasn't just the Tucson. What happened was another piece of evidence, the car seat, was then placed into the vehicle. So they weren't just seeing the Tucson, they were seeing it manipulated with another piece of evidence that was put in there. And that's why I stress to the court, it's absolutely a recreation, because now we're putting together two pieces of evidence for the purpose of seeing them combined and together. For the reasons that I went over this morning, I believe it was a wholly improper recreation and procedure that has caused Mr. Harris not to have a fair trial in this case. And I believe his rights to a fair trial have absolutely been abridged by that recreation procedure that we did. So I would just wanted to perfect the record on that basis, if I could.
Thank you, Mr. Kilgore. Yes, sir.
Nothing. One additional matter, I want to perfect the record on the scan, the motion in limine that we filed regarding this new piece of evidence, that being the scan that the state is going to be showing us tomorrow. I just want the record to be very clear. The motion that we filed was a motion in limine to exclude a piece of evidence that we got mid-trial. And although we made a proffer yesterday as to that, we'll make sure the court understands the court has not seen that evidence. It's never been shown to the court, and that's why we have been requesting to take evidence directly from the creator of that scan and allow the court to actually see the scan. And again, I know that Mr. Rodriguez made a proffer, but I wanted to make sure that the record was real clear to that extent, Judge. So that's all I want to put on the record. Thank you.
Well, the record stands eliminated on Mr. Kilgore's comments.
Thank you, Judge.
Yes, sir. We'll go back till in the morning. Everybody have a good evening.
Thank you, Your Honor.
All right.